innovations. As we are all aware, it is a very important topic related with our intellectual property rights. Whenever we are doing something new, some new innovation, some new R&D, all these things comes in our part. We have with us a very good expert of the country, Dr. R.P. Yadav. He is a founder and managing partner in patent and trademark attorneys. Mr. Ramprakash Yadav started his career in 1987 with a reputed intellectual property law firm as an advocate and patent and trademark attorney and worked for more than 16 years with the firm. He then served National Innovation Foundation, a society of DST under the Government of India as a national coordinator, IPR. Subsequently, he worked with Intel Technology India, a subsidiary of Intel Inclusive USA, as patent attorney for 3 years, and Indian Embassy, and lastly Italian Embassy as senior advisor IPR for 2 years. He has thus earned an experience of about 35 years in the field of intellectual property rights practice. Shri Yadav has obtained special training in Japan as IP protection lawyer in the year 2011 and is an alumni of EPIC JIPII Japan. His contribution to an innovation cell of a university has been recognized by MHRD and AICTE, Government of India, in the year 2018-19. He has traveled to various foreign countries, including US, Canada, China, Thailand, Singapore, Japan, and Dubai, to assess viability of technologies to be acquired by Indian companies, to provide opinions in respect of other cross-border IP issues, and to deliver lectures on IPR's Indian system. Dr. Yadav delivers lectures, talks in the seminars, conferences organized by MSME, Micro, Small and Medium Enterprises, Ministry of MSME, NRDC, National Research Development Corporation, TIFAC, Technology Information Forecasting and Assessment Council, DST, CSIR, CII, and educational institutions or universities since 2011 regularly. I'm actually, sir, thankful to you for accepting our request and delivering this talk, which is very important for all of the technologies, because the technologies do not understand about these legal provisions, how to do for the patent, how to file an IPR. All these things are very important for us. So I will request you to kindly deliver a talk in such a way so that we can also understand. Sir, I would also request you to kindly make a presentation, kindly share your presentation so that we can put it on our website. The video will also be placed on our website so that the participants can be benefited at any point of time. We have with us our Honorable Shri B.N. Dikshit, sir. Sir, would you like to speak two words, please?
Yes, Agrawal Sahab.
Sir, over to you, sir. Thank you very much, sir. Good morning, sir. Thank you.
Very good morning. Sri
Thank you,
Ashutosh
sir.
Ji, Director Legal Metrology. Sri R. Dr. R.P. Yadav Sahab, today expert of the program. He will speak on the intellectual property rights. So this program is organized by the Legal Metrology Director and the Department of Consumer Affairs. There the lot of things are there. The main thing is the Legal Metrology Act 2009, which has been passed by the Parliament, and later on it is implemented by the Department of Consumer Affairs, which is the nodal agency. By which this act and there are the 6 rules are also there. So all these rules along with this act is implemented and enforced through the state government. Main agency is the central government because they are the nodal agencies for the act and the rules, because these are the notified by the Department of Consumer Affairs. So there are a lot of the things, weight and measures, weighing and measuring instruments, and so many other things. So suppose there is a petrol pump, there is a flow meter, gas meters, and so many meters for liquids other than waters covered lot of the things. Like the automatic weighing instrument, non-automatic weighing instrument. So this covers the lot of the things. And what is the specialty of our rules that if anybody is doing R&D and making some weighing or measuring instrument by his process and covering the provision of the rules, they may come to the department and get the approval, and after that they may get the license. So by that way the manufacturer is doing a special work. So suppose they are making any type of load cells. By that they are getting the expertise. That is the specialty of that very manufacturers. That is the intellectual property right. For that they can take the approval from the concerned authority and they can get the license also. And then they can declare that it is their property right and innovation of the load cells. So accordingly, you'll find there are a lot of the sensor in the weighing and measuring instrument. And you think that how many manufacturer of the dispensing pump flow meter in the world? You'll find very less number of the manufacturers are there. Rest are the importers and the dealers are there. So they are working accordingly. So main license, whatever the intellectual property right in respect of dispensing pumps are lying with very few manufacturer of weighing and measuring instrument throughout the world. So similar way you will find about the flow meters also. Similar way they are the other weighing instrument, automatic weighing instrument, non-automatic weighing instrument, many other instruments are there like blood pressure meters are there as well. So there also you will find that it is intellectual property right of the different manufacturers and all that very things. So if you'll go in weighing and measuring instrument, you will find that there are the thousand number of the weighing and measuring instruments are there, and there are the only limited number of the specifications are there. So these specifications are the laws. They are not bounding that to make limit up to that much only. You can go to the any innovations, but you have to follow the government law because you have this government law based on the international recommendations and it has been generated through the OIML International Organization of Legal Metrology and the various standards has been recommended by the BIPM. So BIPM International Body of Weights and Measures, they have invented the various type of seven base units are there, the definition and all those type of things are there. So they are having that very intellectual property right on those very things. So in that way you will find there are the lot of the manufacturer of weighing and measuring instruments and they are manufacturing those very things and they are taking the license from government. So they have the um, right to claim that it is their own innovation and all that type of things. So Dr. Yadav will today speak on that very subject because he is a specialist. So he will tell that where the intellectual property rights is coming and where the intellectual property right is not coming. But I think the where these things has been claimed and it is licensed and approved by government of India, that comes under the intellectual property rights, and that cannot be uh, denied also. So I request Dr. Yadav to speak on that very subject. And I think that all the legal metrology officers and the scientists and industry people who are uh, joining these very meetings So they will be much benefited from our talks, and they will get the much benefit. And in future also they may do any correction if they required on uh, their production and all that very things. So, thank you, Agarwal sir. Thank you, Dr.
Okay,
Yadav
sir.
sir.
Thank you very much, sir.
Thank
Thank
you,
you for
sir.
the kind and motivating words. You
Thank
are
you, sir.
always with us, sir. Thank you. Thank you very much. Now over to you, sir. Professor Yadav sir, please
Okay,
take over.
okay, sir. Thank you,
You
sir.
can share your presentation, sir, please.
Yeah, yes. Sir.
Thank you.
Is it okay, sir? Are you able to see it?
Sir, I'm not able to see your presentation.
It's I shared it, right?
No, not yet.
Okay, I will share it once again.
Voice is clear to others, sir. My request is kindly check your voice if it is you are not able to hear. I'm able to hear properly. So otherwise, you kindly share your presentation with me. I'll share it. I will ask my team to share from their side.
No, this is what is the one. Can you see now?
Yes, yes. Now it is okay.
Okay.
It's just
So,
coming. It is coming. It has not appeared yet, but it is coming.
okay. Is it okay now?
Not yet.
Yeah.
Atulji, is it visible to you?
No, sir.
Not yet. So we are just able to see the blank screen.
Blank screen.
Yes, sir.
Oh God. Team, can you send me that link as you sent earlier?
Link, sir. Sorry.
That link of the meeting he just shared with me.
Yes,
10
sir.
minutes, 10 minutes before. Can you send it again, please?
Link. Yeah.
I think this is logged out from my side.
No, sir. It is not logged out. I am just sharing again, sir.
Okay. Then where is this?
Atulji, are you sharing so that he can directly join?
Yes, sir. Yes, sir. We can say.
Please sharing.
अरे दिव्यांशु दिव्यांशु अरे मेरा वो कहाँ गया है भाई?
Your slide is not visible, sir.
I'm just doing it once again.
No issue. No issue. Please take your time. No problem, sir.
ये तो रजिस्ट्रेशन के लिए लिंक आ रहा है सर.
Sir, the same link can be used for joining this meeting, na? You have already joined. You are inside the link, but we are not able to see what you do. You unshare and again share. Divanshu ji, you please share and again unshare and again share.
अरे यार वो
We are able to see you.
यहाँ से है क्या? हाँ तो रिज्यूम करो ना शेयर. Sir, is it visible now? No.
No, not yet.
Stop.
Yes, again share.
आप शेयर करो. अरे तो वो तो हट गया ना, रुको. शेयर. No.
Yes, now it is visible.
Okay sir, okay. इसको पूरा कर दो. Just a second sir.
Yeah, now we are able to see your WhatsApp. Yeah, your mail. Please share the presentation. Yes. Yes, now it is a presentation.
Okay, Dr. Saab.
Yes, sir. Yes, sir. Very well.
I'm sorry, I'm an old person.
No issue, no issue, no issue, sir.
Well conversant with the latest technologies.
No issue, no issue. Please continue, sir. Please.
So the topic given by Dr. Astosi is that intellectual property rights and their benefits with specific reference to metrology and industrial inventions. So I will start now. What does it mean by intellectual property? So let us understand first that what is intellectual property. So as you have seen on this this slide, that is a property created by the person and persons using its own intellect ultimately for the use in commerce, which is not available in the public domain. So it is, in other words, it's a creation of mind which is not available prior to your creation, and it is for the ultimate use in commerce, that is for the industries and for the public as well. Examples are an invention relating to a product or process, a design of an article, literary and artistic work, and a trademark. And trademark is a word, symbol, and or logos I will discuss in detail in the subsequent slides. So here is the benefits of the, see, what I have said is earlier that this is a kind of product or process. So now what does it mean by process? Product and a process includes all kind of products or processes, whether used in the metrology or used in general by the public or in the industries. Therefore, it is always advisable to protect an invented and novel technology relating to the products and or processes, as discussed, Dr. Saab, in earlier, that there are so many inventions which we have made regarding the measuring devices, and all these are the products which, if we have invented, if we have done something new, then it is always advisable to protect it as an intellectual property. And a novel and invented technology relating to a product or process is an intellectual property, in other words. And this is required to be protected legally. So now comes the intellectual property. So once we have created an intellectual property, now it is our duty to protect it, to get the rights, legal monopoly rights with respect to that intellectual property. And this intellectual property right is the statutory legal rights granted by the government to the inventors, to the applicant, to the creators or owners of the intellectual property, to exclude others from exploiting the intellectual property commercially, that is, for the monetary gain. And why these rights are provided by the government or granted by the government to the applicant? Because the applicant has disclosed complete information about that particular intellectual property in that intellectual property right application. Means the application which is being filed for the protection of the intellectual property, he has to disclose best known method. And as he has disclosed the best known method in that intellectual property application, in lieu of this, in return of this, the government or the concerned state or the concerned department grants the monopoly rights to the applicant. Now, what are the benefits? Why it is so beneficial? What are the importance of this intellectual property right? As you know, that the last century was treated as the century of knowledge, and intellectual property is nothing but a kind of knowledge which is novel in itself. So this intellectual property is an asset. See, it is like a property. Your immovable and movable properties, it is the same, but this is an intangible asset. Means you cannot see it, but you can very well feel it, and can be exploited by the owner for commercial gains. Means the intellectual property which you have protected, you can license it, you can sell it once for all, and you can use it for your own benefit. So this is an asset, intangible asset. Now, IP owner can stop others. Once you register, once you protect your intellectual property, then you have got all the right to stop others from commercialization of that particular kind of intellectual property, which is duly registered and protected by the IP owner, subject to the condition if you have got registration and you have protected legally in a valid manner. Then IP owner can license, as I just now told you, that this is a property which can be licensed. As you have got your own house, you can rent it out, right? You can sell it once for all, and you can dwell into it. Means you can reside it into it. So the same way, the intellectual property, you can license it, you can sell it, and you can use it for yourself for the commercial gains. And this intellectual property promotes standardization and precision in metrology tools. This is the intellectual property. Once you get a kind of intellectual property, or suppose an invention is done, then this becomes, or this is published. Now this is known to the public. Now public can access it. And once you have the information, prior information with regard to a particular subject, you can very well do research on it. So in that way, this intellectual property, benefit of the intellectual property is that it promotes standardization, further research and development, and precision in the methodology tools also. Attract investment and build brand credibility. As you have seen that, see, do you know that this Microsoft, Intel, right, Philips, these are the brands, well-known brands all over the world, and you will be wondering that the value of these brands runs into billions and billions of dollars. So this is what is another benefit of the intellectual property. Inventor, creator, or author of an IP can mention it in his or her resumes, as you are, as all of you are educationists, well educated people. Nowadays, when you go to attend an interview, the interview board asks that how many, see, earlier it was that how many papers you have published. Now the interview board asks that how many patent applications you have filed, and if you have filed, how many patents are granted. And if the patents are granted, then how many out of these patents have been commercialized? That is, the product which you got patented, is it really commercialized? Is it for the benefit of the public at large and the industries? So this kind of questions are being asked by the interview board now. And that is what I said, that you can very well mention in your resume that, look, I have filed so many applications, patent applications. This is what is the number which I have granted patents in my own name. And this IPR certificate, see, the registration certificate, intellectual property right registration certificate, this establishes the legal and valid ownership about the intellectual property. Like if you have got a car, right? What is the proof of ownership? That registration certificate, which is being called as RC. If you have got a house, what is the proof of ownership? Your sale deed, which is being executed in your favor. Likewise, in case of intellectual property, this registration certificate, which is issued by the government of India or by any state in the world, this document itself is a proof of ownership. Then you don't have to produce so many other documents to prove it that you are the owner. This registration certificate, this tells you that you are the registered and legal owner of this particular intellectual property. Now comes to the kinds of intellectual properties. What are the kinds? How many kinds of intellectual property are available? So legislations, there are different legislations which have been passed by the government of India to protect the intellectual property rights. Like first is patent. Patent is to protect the technology. Technologies may be relating to the product or process. And this is protected under the Patent Act 1970. Now trademark. Trademark, as I told you earlier, this is a word, symbol, logo, label. And these trademarks may be a word mark, maybe a label mark, maybe a logo mark. They are protected under the Trademark Act 1999. Now design. Design is to protect the outer ornamental configuration of an item. Any item which is independently sold in the market can be protected under the Design Act as a design, but only outer ornamental feature, aesthetics of an item, and they are protected under the Design Act 2000. And then the copyright, to protect literary and artistic work, as you all know very well. This is protected under Copyright Act 1956. And then you would be aware of GI, geographical indications. This geographical indications is part to protect the specific product generated, maybe natural product, maybe man-made product in a particular geographical area of a country. And this is what is being called as GI, and they are protected under the geographical indications of goods act. And then ICs, some of you would be aware of what are ICs, integrated circuits. So these integrated circuits are protected under the Protection of Integrated Circuit Layout and Designs Act 2000. And then plant varieties invented by the farmers. The act is Plant Varieties and Farmers' Right Act 2000. And then trade secret. See, trade secret is something which is not in fact protected in writing, but it is protected by itself, and there is no legislation in India. But if you go to US, if we talk about the US they have got a legislation to protect the trade secret. So I will give you a very good example of this trade secret when we move forward. And all kind of these intellectual property rights are territorial rights. Means that if you have protected your intellectual property in a particular country, your rights are protected in that particular country only. If you have protected your invention in India and you have got a patent, granted patent in your favor, but based on this patent which is granted in India, you cannot stop the people who are copying in US, China, or anywhere in the world. So if you want to protect your right in the foreign countries, then you have to file the patent applications there in the foreign countries just for the protection of a particular kind of intellectual property, whether patent, trademark, copyright, design. Now, patent. Patent is an exclusive monopoly right granted to an applicant patentee by the government for a limited period of time to practice the invention. Practice the invention means that manufacturing, use, and sale. In lieu of the information's best known method disclosed in that particular patent application with regard to an invention. Just see, this is invention. So the patent is granted in relation to a invention only. And this patent confers the right to the applicant or patentee to stop others from manufacturing, using, and selling the patented product. I will discuss what is invention in detail, but in the subsequent slides, let me talk about this kind of intellectual properties just to inform you that what are the kinds and what are the ways to protect. So in invention, if you see this, I will discuss subsequently in detail. Now let me go to design. So design is outer ornamental feature. For example, ornamental configuration, shape, patterns, and composition of the lines, colors applied to an article. And what is an article? Article means an article of manufacture and includes any part of an article which can be manufactured and sold separately. So design is for a complete article. This may be a part, but if it is capable enough to be manufactured and sold independently, then design rights, then this part can also be protected as a design under the design set. Just see the example. See the fountain pen. It's a noble design, new design. This telephone receiver and handset. It unique design. Then your cars, unique design. This is Volkswagen car, and even the fabric. Just see the Kanjivaram sari. You can protect it as a design. Just see rings, right? All rings, bangles, kadas, which are being used by our ladies. Then sets, tea set. This is also a very good subject matter to be protected under design set. Just see sofa sets. Just see, and I belong to Aligarh, so I thought let me tell you about this. All these different designs, they are protected. They are well capable to be protected as designs, right? These are the garments, as I told you, fabric, garment. This is a fabric. Then it's a kind of coat. Then it's a kind of lehenga, which can be very well protected. And I think you people would be aware of Ritu Berries, who protect their designer suits as a intellectual property under Design Act, and no one can copy it. And the cost of these Ritu Berries fabric suits wears is runs into thousands and thousands of rupees. And the government fee for filing a design application is 1,000 rupees, 4,000 rupees. The total duration or lifetime of a design is 15 years. At the time of registration, it is 10 years, and then you have to renew it for a further 5 years. Let's see trademark. As I said earlier, that it's a visual symbol, for example, a word, device, brand, heading, label, ticket, name, signature, letter, numerals, shapes of goods, packaging, and combination of colors, and any combination thereof capable of distinguishing the goods or services of one person from those of the others. In other words, if I say a trademark identifies the manufacturer of that particular item. Like if you come across that Sony, then you remember that, oh, it's a product of Sony, and Sony means the best kind of TV. As you come to know Bata, Bajaj, you come to know that these are the products which has come from the house of Batas, and it would be a good product. Like Voltas, if you come to know Voltas refrigerator, Voltas AC, it means it's a product of Tata. So it's trademark is a kind of intellectual property which identifies the manufacturer of that item. See, kinds of trademark like word mark, logo mark, label mark, collective trademark. You might have seen people use it just for the association of persons. Collective trademark like GI, geographical indications, like certification marks, like you see wool mark, and then other marks which are being specifically mentioned and used by the particular manufacturers. Just see examples: Tata, Sony. It's a word mark. This is label mark, logo mark, right? See Tata, Dabur, Bajaj, and then Cadbury's. Then Gems, again Cadbury's, and then Dabur, Chyawanprash. These are all these are the label marks. An example of collective marks is like GI, geographical indication, and then example of certification mark are wool mark and ISI mark and GI. Just see, this is the unique thing. The bottle of Coke, Campa-Cola. Is it being treated as a trademark worldwide? No one can copy the design of this bottle. No one. You might have seen different kind of soft drinks, but no one can copy the design of this bottle. Like Yakult, this is again design. Yakult is a kind of fermented milk, which is very useful for the digestion purposes. And this bottle itself on the right hand side, Yakult, this has been protected by the owner of this trademark as a trademark worldwide. No one can claim, no one can manufacture and this kind of design of bottle for this kind of product, and not even for this kind of product for any kind of drink. No one. Government fee is for filing a trademark registration application, this 4,500 for individual MSME companies, 9,000, and lifetime is innumerable, indefinite lifetime. At the time of registration, this is registered for 10 years, and before the expiry of 10 years, you have to renew it for a further period of 10 years, and you can continue it for hundreds and hundreds of years. This is very important. Just see, you cannot use the symbol encircled R. R encircled by a circle cannot be used unless you have got a registered trademark in your field. You can very well use trademark. Trademark, you can say that, and trademark shows that it is your trademark. But encircled R shows that it is your registered trademark. So please ask the people not to use the encircled R on their products until they get registration, and the registration certificate is in their hands. Copyright, as you know very well, it's a kind of literary and artistic work. Cinematographic film and sound recording. These are all kinds of copyright. Literary work includes written text, source code, computer program, table and compilation, including computer database. Artistic work includes painting and sculptures, engraving, photographs, whether or not any such work processed in article work of architecture, building structure, any other work which is of artistic craftsmanship. So anything which involves artistic craftsmanship can be protected as a copyright, as an artistic work. Dramatic work includes piece of recitation, choreography work, entertainment, dumb show. Music work includes music including any graphical notations, but does not include any word or any action intended to be sung. Cinematographic film, you must be aware of. Three Idiot was a picture which was being released by the people, and someone tried to copy it, and then he was stopped. Sound recording, as you might have seen T series, there are so many cases between T series and other people who are copying their sounds and their videos and audio. Comment fee is from 500 to 5,000 depending on the nature of the work, and the term of the copyright is for the whole lifetime of the creator of the copyright, and 60 years after demise of the copyright. Discovery of India was written by Sri Jawaharlal Nehru, and the royalty was being enjoyed by even Indira Gandhi and even subsequently. So the lifetime of the copyright is very long, the whole life of the creator of the copyright, and then 60 years after demise. And then geographical indications, as I told you, I will give you some examples here. This indicates the word indication according to the GI Act indicates that name, geographical figure, and this. And goods may include agriculture, natural or manufactured goods, maybe man-made goods. Just see some of the examples here. This is Darjeeling tea, right? And just below the Darjeeling tea, it's a symbol of GI of Kangra tea. And then on the right hand side top, this is Kulu shawls. Just see, these products come from Kulu only. This kind of shawl having this kind of border. And then Madhubani paintings comes from the Madhubani, Bihar. And these paintings, you see, there are certain people who are involved in doing this. Darjeeling tea is being grown, and it has got a unique flavor because the climatic condition of that Darjeeling in a particular area are like that they give a different kind of flavor. Like Kangra tea, Kangra is a place again, and there the climatic conditions are different than the Darjeeling, and it gives a different flavor, different kind of tea. Like Kulu salts, people are involved there, and they are weaving this kind of salts, this kind of having this kind of border. So people are there. So GI means geographic specific product. Geography is specific product, whether this is natural, whether this is man-made. Like tea is natural, but Kulu salt is man-made. Madhubani painting is man-made. Alagsi, this guava, Allahabad guava. Then below it is a Fulkari design of Haryana. And then a Pashmina shawl on the right hand top side. And this is GI. They have got a GI tag for this. And then this is Mysore sari. This kind of sari is Mysore sari. It's heavy saris which are being woven in Mysore only, around in a particular area of Mysore. Then this is Firozabad glass. They have got a GI because all bangles and all kind of glass work is being done in a large quantity in Firozabad. And then Kannauj is famous for perfumes. They have also got a GI tag for their product. Government fee is 5,000 rupees, and GI is like indefinite lifetime. This is registered for 10 years at the time of registration, and then has to be renewed before the expiry of 10 years. Every 10 years, it has to be renewed. And the specific thing in this GI is that GI is registered in the name of group of people, cooperative societies, NGOs, which are working for the welfare of the people of that particular area. GI is not registered in the individual name. Individual means individual natural person or even the legal person cannot get a registration. No company can get a registration of GI. But if you see the trademark, they are being registered in the name of individuals. They are being registered in the name of individual companies. No group of people. But GI, of course, group of people. GI specifies or defines that this particular product has come from a particular geography. But if you see trademark, this never defines that what kind of product is being sold under a particular kind of trademark. See, by word means Sony. You cannot foresee that, okay, Sony is only meant to sell the electronic item. No relation. But if GI, it has got a relation. That is what is the difference between GI and trademark. Trade secret, as I told you that I will let you know. Trade secret is a kind of intellectual property, and it intellectual property of a particular person or particular company, so long as they are able to keep it secret. As this secret is leaked or this goes in the public domain, you don't have any kind of right as a trade secret on that particular knowledge, confidential information. So trade secret is, as long as you are keep it secret, confidential, this is your property. As soon as it is published or it goes into the public domain, you lose your right. Now I will give you an example. Some of you would be aware of. See, Coke is a soft drink, Pepsi is a soft drink. They are two different brands. They are manufacturing soft drink, right? But if you see, the Coke has got a particular flavor, particular taste. Similarly, the Pepsi has got a different kind of taste, and both the taste are good. Means people like it. No one worldwide can copy this taste of Coke and Pepsi. Do you know why? Because it's a kind of trade secret. Trade secret means when the complete dope is prepared in the manufacturing facility of Coke and Pepsi. One person goes and he mixes maybe a kind of chemical or something. No one knows what is it. Is it a chemical? Is it a fermented product? What is this? Nobody knows. And he mixes that particular chemical or particular special kind of product into that complete dope just to bring this kind of taste. In both the companies, it is being done. And this composition, they are keeping it as a secret for hundreds and hundreds of years. And you will be wondering that in both these companies, only two people knows that what is this composition. Only two people. These companies have got the employee strength of thousands and thousands of men, or even more than lakhs, if you see worldwide. But only two people are aware of that what is to be mixed in the dope, which is being final for as a soft drink. And you will be wondering to know that these two people, if they are going to attend a meeting in the same country, at the same place, they will not travel together. They will travel independently. Though they are going to attend the same meeting at the same place, because people of these companies, they may that if some mishappening happens, then this complete secret will go with these people. So only two people in all these in these two companies aware of that what is that kind of mix, or it's a chemical, it's what is this, nobody knows. And that is the best example of trade secret. Now let me come back to the patent, because this session is meant just for the inventions, that what is an invention. So let me come back to that, what is an invention and how do we understand that this kind of invention is patented. Just see that the patent is meant to grant the monopoly right with regard to an invention. And an invention, as per an invention in general, I will let you know. It's a kind of research and developed product, right? In general, means an invention means that something new has been done. But then a patentable invention means that a product or process, product may be a device, machine, composition, process may be used for preparation of a product, and this is patentable only when the product or process is novel, involves an inventive step that is non-obvious, and industrial use, that is, this invention can be used in the industries and the product can be made for the use of the public at large. So in invention, as per Indian Patent Act, section 21J is that any product or process which is number one, new, novel, involve an inventive step that is non-obvious, and is of industrial application. So when an invention fulfills these two requirements of these three requirements, only then it is a patentable invention. If an invention is not new, is not non-obvious, is not useful, you will not get a patent for it. So let's understand one by one that what does it mean by new, novel, what does it mean by non-obvious, and what does it mean by useful. Just see here. So invention means anything which is new. Just see, simplicity is no bar for the grant of an invention. Just see the first figure. It's a kind of rod, simple rod, no use, can be used for the building construction, or maybe for manufacturing a particular item out of it. But if you see the second figure, which is a sieving needle, we use it at our home. Our sisters and mothers use it just to repair the small repairing work in the home. But with the passage of time, invention or technology is being developed, continuous process of development of technology. Then a sieving machine came into existence, and then there was a requirement of a sieving needle, and somebody applies his mind. See, from the simple rod, he made the sieving needle, manual sieving needle, and then again from the same rod, he made the sieving needle, which is being used in the sieving machines. And just see the construction. The simple needle, manual needle, have got a sharpened end at one end and a hole at the other. It is different than a simple rod. So all these three criteria, novelty, technical advancement or non-obviousness, and usefulness, they are being fulfilled by the needle. If you see the third figure, all these three ingredients again are being fulfilled, because this needle is not a simple kind of needle as in the figure 2. This third figure is a unique needle. It fulfills all the criteria of being a patentable invention, because this is new in construction, means the hole is provided now on the sharpened end, and the other end is made in such a manner that it fits into the lever of the sieving machine. Channel, thread guiding channel, if you see from left to right, a thread guiding channel. So this, if you want to put a thread into this hole, just follow this channel, and then it will enter into that hole which is provided on the sharp end. So what I want to communicate or to make you understand is that simplicity. An invention may be a simple invention, but if it fulfills these three criteria, that is, if the product or process is new, novel in construction, if the inventive step is involved, that is, the product or process is non-obvious, and it is of usefulness, then it is a patentable invention. Let us understand what is meant by novel, new. What does it mean? How do we come to know that my invention, which I have done, whether it is related to a product or process, is novel or not? So an invention which is not in use or known in the prior art is a novel invention. New and novel invention. Not known in the prior art. Now, what does it mean by prior art? Prior art. This is being defined in the Act as such. Prior art includes printed publications anywhere in the world and use of the product or process by the public forms part of the state of art. So suppose, like you might have seen, there are so many small articles which are being used in the agriculture field and in some industries. They have been customized. They are not published, right? No one knows about it, but they are in fact being used in that particular industry. So this, the in fact use, the real use of an item, if it is not at all published, is also being treated as a prior art. And if it is published, then there is nothing to worry. So publications, all the items or product or process regarding which the knowledge regarding which is published in the publication, it becomes a prior art. If at all the invention is not, or invented item is not published in the publication, but if it is being used in by the people, then also it comes into the prior art. So this is what is prior art. So this is way you can find out that whether your product or process is novel or not, by finding out the prior art. So we usually conduct the prior art searches. You can also conduct the prior art searches at your own, right? Just to find out that whether my invention is novel or not. Now, prior art does not include, see, everything is prior art. Maybe if it is published, it's a prior art. If the product or process is known or it is being used, it's a prior art. But there are certain exceptions. Prior art does not include technology known outside of an organization and not used commercially anywhere. Technology which is known, which is not known outside the organization. Like I worked with Intel US. There are so many technologies there which were not being published, which were not being patented, but they were known only to the people who are working there inside the organization. They were not made public. They were not available in the public domain. That kind of technology, that kind of publication even will not be treated as a prior art. In-house publication, as I said, in-house publication, not meant for the public, not available in the public domain. This publication, of course, see what happens, as I told you that I worked with Intel, there are certain technologies which they think, the board of directors think that, oh, it's not a technology which is to be patented. What they do is that they publish it in the in-house publication, just to let the other engineers who are involved in research and development know that, look, this work has already been done. You don't reinvent the same thing. You do something new. So they publish, and there are in-house publications available, just to let the people know that, look, up to this stage, the work has already been done. If you want to do research, please do something new and beyond this. So these in-house publications, they are not being treated as a prior art. Public display of in an industrial application. Suppose you have invented a kind of device which is for the public use, and you have simply exhibited it in an exhibition. And that too with the consent of the true and first inventor. And this will not be treated as a prior art because it was just shown, exhibited in an exhibition. Publication of an invention without consent of the true and first inventor or applicant. See, sometimes what happens is that there are group of people who are working on a particular project, and one of them, though a group of people was working, but one of them just to get that, look, this work belongs to me, if it is published by him or her without the consent of the co-workers or co-inventors, then also it will not be treated as a prior art because the other people did not give consent. But of course, if it is published, having the name of all those people who are involved in the process of inventing this new product or process, then it would be treated as if this is a prior art. Example of prior art I will give you. Look, known composition. A composition is known having three ingredients A, B, and C. And A is being used in the percentage of 20 to 30%. B, substance B is used in the 30 to 50%. And C is used 40 to 60%. So a composition having A, B, C in the range of 20 to 30 A, 30 to 50 B, and 40 to 60 C is known. But then another person invented a composition wherein A is between 22 to 28, B is 32 to 48, and C is 42 to 58. So just see these ranges 22 to 28, 32 to 48, and 42 to 58, right? It is within the range of known product, known composition, 20 to 30, 30 to 50, and 40 to 60. So this subsequent invented composition is not a novel composition. And this first composition having 20, 30, 30, 50, 40, 60 will be treated as a prior art for the subsequent composition. So in this case, what will happen is that subsequent composition is anticipated by the prior art because all the ranges are within the range which are already published or which are already known, and that becomes a prior art. Another example, if you see, just see here. You all know we most of us comes from blazes. If you see in the blazes, there was no stool, means, and I'm talking of ancient time. And what we used to do is that we were having chabutraj and we will sit on that chabutraj. And sometime what people were doing it that, okay, some tree is falling down, then they will cut the stem, and that stem will be treated as if this is a place for sitting. But then somebody uses his mind, invented the stool having 4 legs and a platform secured on the top of these 4 legs. All these 4 legs are secured with each other by means of connecting rods or connecting pieces. So this stool is the first one. Now then somebody, and if you sit on this stool for a long time, your back will be aching. Your back will be aching. So somebody applied again mind, and what he did was that he raised the two legs up in the upward direction and made a backrest, and then the chair was invented. So in relation to this chair, stool is the prior art. But then this chair is not anticipated by the prior art, because the prior art is stool without having backrest. But here, if you see chair, it has got a backrest, which is new, and it is fulfilling all the three criteria: novelty, non-obviousness, and usefulness. But for this chair, stool becomes the prior. Now then this chair can also be set on a space. It cannot be cannot be displaced easily, but you have to lift it if you want to put it at some certain other place. So then what people again rather applied his mind, and what he did was that he made a revolving chair which can very easily transported from one place to another place on the wheels. And you can sit on this revolving chair for hours together. You will not feel fatigue if you are sitting on this table, because you can stretch, you can rotate yourself, and you can ease yourself. But for this rotating or revolving chair, this stool and chair becomes the prior. And these chairs and stool, they are not anticipating this revolving wheels, because this is a kind of new item. It's not anticipated by chair or stool. And then again, this chair also is meant for the people who are fit, means have 2 legs and have 2 arms just to do their job. But then you see, somewhere in our houses, in so many places, so many houses, there are people who are disabled, right? Means some of them don't have one leg, or sometimes 2 legs. Some of them don't have arms. So what people did was, and if he is thirsty, if he wants to have a glass of water, what he can do? He can't do anything. See, he has to wait till someone else serve the glass of water to him or her. So somebody again applies his mind, and he made a wheelchair. And this wheelchair can be operated by the person who is maybe disabled. If he has got one arm only, then also he can operate this chair, and he can go to the place where the water is there, and he can have the water. He can go to the dining table by himself or herself. There's no need. He will not require the help of any other person. So all these are the invented item, and stool is the prior art for the chair. Stool and chair is the prior art for the revolving chair, and all these three are the prior art in respect to the wheelchair. So this is the way you can find out whether my invention is known in the prior art or not. Suppose the stool is already there, and you also find or invent a different kind of stool where maybe round shape. Then round shape stool, for this round shape stool, this stool who has got a platform of square shape will be treated as if it is a prior art, because it has also got 4 legs and a platform mounted on the 4 legs on the top end there. So both the stools, though the shape wise, look wise, they are different, but will not be patented. That is what I mean to convey and to make you understand that what kind of items or what is the prior art, in fact. Now, just to find out the prior art, because we want to know that whether this is published or not, whether a kind of patent is already available on with respect to my product or process, what we do is that we conduct prior art searches, and we usually use these websites, which are free of cost website, means you don't have to pay anything. Indian Patent Office website, that is www.ipindia.nic.in. US Patent Office website, that is www.uspto.gov, government. And then European Patent Office website, that is http://ep.spacenet.com. And then now it's a worldwide, WIPO is there, right? World Intellectual Property Organization website. This is www.ip.wipo.org. And also Google for patent. You might be know you might know that Google patent is also there. And on this Google patent, just you put the keywords and you will come to know that what kind of product are already available with respect to that product or process. And let me inform you, you must be aware of, some of you would be aware of, that today is World IP Day. 26th April is being celebrated worldwide as a World IP Day. So I'm lucky, and we all are lucky that we are discussing intellectual property. We are having a discussion about intellectual property, and today is the World Intellectual Property Day. All the best for this World Intellectual Property Day of today. 26th April is being celebrated as World IP Day. So now, how to find out whether my invention is non-obvious? Just, and what does it mean by non-obvious? Means, or inventive step means features of an invention, that is technical advancement or economic value or both as compared to the existing knowledge, that is prior art, relating to a product or process, which makes the invention non-obvious or a person skilled in the art. So this is what is non-obvious. Means if you have done something new, if you have made technical advancement which were not available in the prior art, then your process, your product is a non-obvious product. Now let me give you an idea. What is the test? How to find out that whether my invention is non-obvious or it has certain technical advancement or not? Technical advancement you will be finding out, or you will come to know when you compare the prior art with respect to your invented product or process. But a general test I will tell you is that suppose you along with your peers, with your friends working in a lab, and there is a idea clicked into your mind, and you discuss with your friend that look, this kind of item, this kind of product I want to make. And if your colleague, your fellow researcher, if he is bound to think that, oh, is this, can it be? Then you'd simply think that my item is non-obvious. It's not obvious. Because obvious things can be, he will answer very well, oh, what is this? It's very obvious. Like I will give you my example. See, when I joined Intel in Bangalore, because I belong to district Aligarh, now it is district Hathras of UP. And I went to do the job with Intel, and I was transferred to Bangalore, far away from Aligarh or Hathras. So I used to talk to my parent, to my brother over phone. And this is what I'm talking about, 2004 to 2007. Would be aware of there were PCOs there to make the calls, or if you have your own set of telephone in your maybe mobile phone, or maybe your this landline phone, then you were able to make calls. Otherwise, you have to go to PCO and make a call and then come back. And this was rather worrying me. Every week I have to talk to my parents, and I was not able. And during those days, when you go to PCO, the charges were per minute. 3 minutes, one call. And if it is 3 minutes, 1 second or 2 seconds or 5 seconds, another call is charged for 3 minutes. I was just worrying that. And when you talk, you don't see the watch that, okay, have I talked to 3 minutes? Then I should switch off. or have I? And it was sometime, it was all the time it was happening that we are talking, and 10 seconds is over 3 minutes. And then he will charge me for 2 calls. And calls were very costly those days. 2 calls at that time means 50 rupees, 40 rupees, 60 rupees sometimes, depending on the distance. So there was an idea came to my mind that, look, can't I do something, or can't I make a kind of device which tells me, informs me before 5 seconds of the call? Means 2 minutes 55 seconds. It will give a beep, and then I will be aware. I will come to know that, look, my call is going to complete within 5 seconds. Either I will drop the call or I will continue for another 3 minutes. And this idea clicked to my mind, and I discussed with my friend who was there, who was a electronic engineer, MTech also in electronics. And I discussed with him that, look, Mr. Murthy, can't we do this thing, and can't we get a patent for it? Because it's a new kind of thing. And instantaneously, he did not think for that. He instantaneously told me, oh Ram, what are you telling? This is all known. Like, where is it known? Well, let's go to PCO. So we went to PCO. We were having our own mobiles, but then we went to PCO. And I made a call, and there was a instrument which was attached with that set of landline. And exactly at 2 minutes 55 seconds, there was a beep. And the PCO operator told me that, sir, your call is going to complete. Do you want to continue? And if you want to continue, then he will press a button. And then for another 3 minutes, you can continue talking. Or you say that, no, I don't want to do that. Then he will again press a button and your call is disconnected. But then as I made this point to my friend, I said, okay, this is not available. Maybe Murthy, maybe this is available in this landline set, but it's not available with the mobile. He said, there you are right. It's not available with the mobile set because there's no kind of beep comes from the mobile telephone. And there you can do. But then with the passage of time, within the next 1 year or 1.5 years, this call became per second. Now, if you talk to 61 seconds, your charges are for 61 seconds. If you talk to 100 seconds, your charges are for 100 seconds. So this is obsolete now. The technology, which was very important in the mobile set during 2004 to 2007, now it is completely obsolete. There are so many technologies, thousands and thousands, lakhs and lakhs of technology, which were very important during the early days, but now they have become obsolete. They have become of no use, right? So this is the way we can find out whether our invented product is non-obvious or it is something which is obvious, not an invention. Examples, just see. I will give you an example. You might have seen the internal combustion engine. Most of you are aware of what is internal combustion engine. And in the internal combustion engine, if you see, carburetor of an engine is the heart of the engine. Carburetor is a kind of part, kind of component in the IC engines, which mixes the fuel with the air, environmental air. It mixes the fuel with the environmental air in such a manner that this mixture of oxygen and fuel goes into the piston cylinder assembly. It is burned there, generate gas, and this gas, due to the pressure of this gas, the piston and cylinder assembly start working, and then your engine works. Now, in the early days, this carburetor was operable only on the liquid fuel, petroleum fuel, like petrol, diesel, right? So what happens was that the person, somebody applies his mind, and what he did was that he improved or he modified this carburetor, and now this carburetor is capable enough to be operated on gaseous fuel. Instead of petroleum fuel, now it is capable enough to work on gaseous fuel like CNG, PNG, and all that. Now, just see. Here, if you see, this carburetor, which is being invented by company B or by person B, this fulfills all the three ingredients of the invention. This fulfills that this subsequent carburetor, which is capable enough to work on a gaseous fuel, is not a kind of obvious product. No, it's not. It's a non-obvious product. Nobody could understand before it. But when this person made this available to the public, this became a kind of obvious thing. So this is the test of non-obviousness or obviousness. Another example, if you see, composition of a drug improved by adding, deleting components from the composition without changing the properties required to cure a particular disease, and the efficacy of the drug is increased. There are so many drug compositions, right? If you increase the number of components into the drug, and if the property are not changed, but the composition as such or drug as such becomes efficient, then it would be treated as if this is non-obvious. Let us discuss with this Novartis case. What happens? Most of you would be aware of this Novartis case. In 1998, patent application was filed by Novartis, claimed Gleevec, the beta crystalline from the imitamycin. 1993, during the time of India, did not allow the patent on product. Novartis had patented imitative with salt, vaguely specified in US. But when the India became the member of WTO, and in 2005, rather 2000, there was a provision. Trademark Patent Act was amended, and all the it was under the compulsion. We had to change our law as we became the member of WTO and TRIPS. Then we have to allow the product patent. Before that, 2000 till 2005, we did not allow the product patent. There was process patent only with regard to drugs and pharmaceutical products. But then in 2005, we had to allow the product patent. And what this Novartis did was that they invented something in 1998, got the patent there in US, and they filed another application there in US with the change of certain changes in that composition, and they filed the PCT application here in India also. And after 2005, there was a box, PCT box. This application was lying down in that box, and when it was opened in 2005, this application came to the attention of the Indian Patent Office, and the Patent Office examined it, and the Patent Office rejected this the patent application of Novartis under Section 3D. Section 3D means this mere admixture. Nothing new. This composition which is now being patented and claimed is not efficacy is not proved. It's not efficient than the older one, and then it was rejected by the Indian Patent Office, because what they did was that one of the component which was there in that particular composition, they used the derivative of that. Simple derivative, no change, nothing, because it was a derivative. There was no chemical change, no composition change, and the quality and the quantity remains same, and the efficacy was not increased because it was a derivative. And then it was rejected by the Indian Patent Office. It was rejected by the Madras High Court, and ultimately You know it. This Novartis is a big company. It's a worldwide known company for the pharmaceutical products and drugs. And they filed the case in the Supreme Court, and even the Supreme Court in the month of April 2013, they rejected the case based on that. Look, this is not a invention because this is nothing. This is not non-obvious. No technical advancement has been done. It's simple obviousness. Based on the obviousness, it was rejected. Industrial use. How to find out whether the product or process is useful or not? Let us have certain kind of test. If the product can be made in an industry and is useful for the public at large, then it would be said that it is a useful product. Similarly, if the process can be used in an industry to manufacture a product for the public use, then it would be treated that it is a useful product. But suppose you invent a kind of soft drink which is not good. This is rather unhealthy composition of a soft drink. Then you will not get a patent for it. You will get a patent for only the soft drink which is useful, which is beneficial to the people. But a soft drink like alcohol, it's a kind of hard drink. Otherwise, it's being called as hard drink. So if you invent a new composition of a hard drink, you will not get a patent for it. You will get a patent only when the product is useful for the public at large. See some examples which do define like a cigarette burning tool. Just see, it's a convex lens which is fixed at the upper end of a kind of clip, and there is a clip provided at the lower end of this strip, and there is a handle to hold it. And we all know that when we were in junior classes, then we used to take out that convex lens in the sun, and then we focus the sun rays at a particular point, and this paper will burn. Likewise, this is a device. But do you think this is useful? Though it is new, technical development is there because there is a constructional difference. There is a different construction. But it is not useful because nobody would like to keep it in his pocket. Likewise, if you see the second one, it's a kind of jacket. Single jacket can be worn by husband and wife, but can you do it in the public? No. So the ingredients of novelty, non-obviousness are there, but usefulness, it's not useful. Cannot be used in the public. No fun. You will not get a patent for it. Likewise, the third one is just see. Like to protect their shoes, and somebody what he did was that he put a small umbrella on the tip front end of that shoe just to save it from the rain, just to keep the shoes shining. But is it useful? Will somebody wear such kind of shoes? No one. No one. So this is the process of usefulness is not solved, right? Nothing. Nowhere. Where to file a patent application? Patent Office, Delhi. The state of Haryana, Himachal Pradesh, Jammu and Kashmir, Punjab, Rajasthan, Uttar Pradesh, Uttarakhand, National Capital Territory of Delhi comes to Delhi. Patent Office, Mumbai, all state, Gujarat, Maharashtra, Madhya Pradesh, Goa, Chhattisgarh, Union Territory, Daman, Diu, and all that. Then Patent Office, Andhra Pradesh, Karnataka, Chennai, and then Kolkata, rest of this. So this kind of, there is a, the whole country has been divided into 4 zones, east, west, north, south, Delhi, Kolkata, Madras, and then Chennai. So 4 places is the patent office. There the patent application can be filed based on the jurisdiction of the applicant. There were certain patent applications which were being filed by CSIR, NPL, your NPL only, National Physical Laboratory, it's a CSI lab, and obtained a patent regarding high precision time and frequency standard. ISRO filed a application patent regarding onboard data calibration system. A patent application has been filed regarding pressure gauge calibration devices. So it's a kind of calibration devices which have been filed. Term of the patent, lifetime of the patent is 20 years. It runs into 20 years. In India, the patent has to be renewed every year. Government fees to file it in case of individual applicant, educational institute, government educational institute and startup companies, MSME companies, 1,600 rupees, and then 8,000 for a legal entity other than the above. Now the question comes in that can a patent application be filed for the world kind of patent? See, international patent, there's nothing like international patent, but of course, international patent application can be filed under the provisions of the Patent Cooperation Treaty, and this is being called as PCT. So a PCT application can be filed, and where all the member countries who are the member country of WIPO and TRIPS, they agreed that okay, if a single application is filed, it would be treated as if this is filed in all the countries. But then this was the international phase of filing. But if you want to protect it really in a particular country, you have to enter into the national phase. And when you enter into the national phase, you have to follow the rules and regulations, the laws which are existing in that particular country. You have to pay the fee. You have to fulfill all the requirements of that particular country just to get the patent granted there in that country. See the data. When I started my practice way back in 1987, the total applications which were being filed was 180 to 200 patent applications. 2010, they became 38 to 39,000. 15, 45 to 46. And if you see 2024, more than 1 lakh patent applications were filed last year. This is what is the importance of intellectual property rights, specifically the technologies which are being invented by the people worldwide. Till 2000, rather 2020 even, if you see 70% applications were being filed by foreign inventors or foreign companies. Only 30% applications were being filed by Indians. But you will be happy to know that these 70% applications which were being filed by the foreign people, maybe individual or foreign company, 70% inventors were Indian. Know it very well that brain drain is taking place from India. We have got brains. We have got the people who have completed their education from IITs and IIMs, but we are not able to retain them in this country. They are going out, working for the other countries like in US, America, Japan, no, somewhere, everywhere. Indian people you will find in each and every country. They are working for the other countries and making the inventions there, and they are the inventors. So there is a need of the hour that what we should do. Why to retain this brain in our own country, in our own country, for making our country as a developed country. Government has to rather think about it. Let's go ahead. Dr. Astos, have I got some more time, or I should stop here?
Sir, you can take 5-10 minutes more. No problem, please.
Okay.
10 minutes.
So what we have discussed till this time is that everything under the sun can be patented, right? every product, every process is a patentable product or patentable process. But there are exceptions. Section 3 is given in the Patent Act, Indian Patent Act, which says that these are the things which cannot be patented. Means they are not patentable as per the rules of the Indian legislation. So first is the invention contrary to well-established natural laws. For example, perpetual motion, gravitational force. These are the principles, right? These are the scientific principles. You cannot get a patent for it. But it does not mean that if you make a device which may be functioning based on these principles cannot be patented. That device can be patented. For example, if I invent a device which gives me an indication before 5 seconds or before 10 seconds that look, there is a bhucha, right? Then this device is patented. Invention which, and this is section 3A, which would be contrary to public order or morality, which is injurious to human health, animal life, or this. As I gave you the example, if you make a kind of hard drink which is not good for human beings, if you make a kind of drug or pharmaceutical product which is not good for human beings or animals, you will not get a patent. This is 3D. Mere discovery of scientific principle or formulation, abstract theory of mere discovery like this substance occurring in nature. This is 3D. So mere discovery, like microsomes, micro modules, they are available in the nature. But if you have isolated these organism, microorganism from the natural product, and if you say that I have invented it, no, you have not invented. You have simply isolated it from the product in which they were residing or they usually reside. Isolation of microorganism or anything which is already available in the nature, that's not treated as a invention. Section 3D. Section 3F is also there, which says mere arrangement or rearrangement of the known devices working independently. That is section DF. Oh. Section 3F. That is section 3F, where it says that mere arrangement or rearrangement of the known devices not working independently is not patented. If I give you an example here, when I was with NIF, National Innovation Foundation, Government of India, we used to conduct the kind of competition where we call the entries from the children who are studying in primary schools. So there was an entry of third standard or fourth standard student, and he said that I have made a kind of walking stick, which will and with the help of which you can rather walk even in the night. And what he did was that he took a stick from the market, put a small dynamo on the bottom end of it, and then connected this dynamo with the battery, a small battery, just to hold the energy in it or store the electricity produced by the this generator. And then there was a electric bulb like this torch bulb with a switch. So when you walk, there is a pressure, and the dynamo start working and generate electricity, which is being stored in this. And when you switch on, you will get a light like your torch. Now, if you see, everything is known here. Stick is known, dynamo is known, battery is known, bulb is known, but they have been arranged in such a manner that if you remove any one of them, the whole system collapses. If you remove bulb, you will not get light. If you remove battery, you will not get light. If you remove dynamo, you will not get light. So this does not fall into 3F, because each and every component is working interdependently, not independently. And suppose I have invented a walking stick. And what I did was that I took a stick from the market, I took a dry cell battery and just clipped it on the upper portion of the stick. And when I want to walk in the night, just switch it on and you can walk. This is a item invention which is anticipated by or is not patentable as per section 3F, because it's a mere arrangement or rearrangement of the known devices, because both the things, stick and dry cell battery, they are working independently. There's no interdependency upon one another. And then substance obtained by mere admixture resulting only this properties, components, or new product, section 3E, aggregation of the properties, no patent, no invention. Mere arrangement to rearrange 3F I have discussed. Method of agriculture and horticulture, section 3H, you will not get a patent. Method of treatment of human being, you will not get. Product, pharmaceutical product, drug, you can get a patent for it, but not for the method of treatment. If you have followed a particular method to just to treat a person or human being or animal, that process patent you will not get. Plant and animals in whole or part thereof, because there is a separate act for it. Mathematical, business method or computer program per se, you will not get a patent for it because it is a literary or artistic work. Then literary artistic work, musical item, you will not get a patent for it. Mere scheme of rules, again, you will not get a patent for it. Mere presentation of information, like my presentation, it's a kind of mere presentation of information, section 3, and you will not get a patent for it because the copyright is there, and I might have also written somewhere that this is copyright RP Yadav. And then topography of integrated circuit, section 3O, you will not get a patent for it. Integrated circuit, there is a separate act. Invention relating to traditional knowledge, 3P, you will not get a patent for it because this is like you see that turmeric case, right? We in India were well known that what are the useful of that why this turmeric is so useful. This has got wound healing properties, and this person who made the invention there in US based on this turmeric, you know who was he? He was an Indian person. He was an Indian who was well aware about the properties of this turmeric, and he used that turmeric into a kind of ointment just to remove the pain and wound healing kind of properties. And it was rejected when CSIR took action against them. And after this, the US patent requested the Indian government that, look, we don't know whether you people are aware of the usefulness of this turmeric because it's not accessible. There's no publication available. And then Mr. Maselkar was the Director General of CSIR, who proposed to the government of India to make it digital TKDL, Traditional Knowledge Digital Library, which is now existing, having the entries of thousands and thousands of traditional knowledges with regard to the process, with regard to the components, with regard to these natural herbs. Everything now is available in the TKDL. An invention related to atomic energy, section 4 of the Indian Patent Act says that anything which is related to atomic energy, you will not get a patent for it because it may be used against the security of this country. It's a quiz. I'm keeping it because the time is not allowing. So thank you very much, Dr. Astos.
Thank you very much, sir, for your brief and very nice presentation. Actually, I have heard your presentation earlier also, so I was aware of that. My request is we will continue to take your help in future also. And also, I will suggest to a few of my friends who wants to get some, some help in this trade name or this registration of IPR, where you can help them.
Please.
Thank you. Thank you very much, sir. Thank you. Now, Atulji, can we take some photographs? Can you take all these participants on the screen?
Yes, sir. Yes.
But then everyone has to start
Yes.
their videos.
Kindly, yes, kindly switch on your video and switch off your mic, please.